All right, so we're going to get started here. If anyone cannot hear us who's on the line, please do send us a quick chat and we will deal with any technical difficulties. So first off, good morning, and thanks to all of you for joining us on our third installment of Tevora's GDPR webinar series. Our webinar today is entitled Privacy, Security, and GDPR, a Legal Perspective. If you have listened in on our previous webinars, Christina and I have gone through an overview of GDPR, its potential impact requirements, how to run a privacy impact assessment, and most appropriate for today's discussion, how cross-functional privacy and GDPR compliance is. In tandem with your technical and operational teams, it is imperative to have a strong legal viewpoint and framework for approaching GDPR. With that in mind, we wanted to convene a group of legal experts focused on a multitude of industries to get their thoughts on how GDPR is going to potentially affect U.S. companies from the legal side of things. Okay. So for today's webinar, we're going to take you through an overview of three major industries and how GDPR may affect them, special GDPR topics to keep in mind for each of those industries, as well as any predictions about GDPR or general elements of the legislation to focus on.
And we'll do Q&A for each one of those sections. So if you do have questions as we go through each topic and each speaker, please feel free and put that into either the question section or the chat section, and I'll go ahead and field those and ask the presenter as we're coming to that particular section.
Okay. So as always, the moderators for the broadcast today are Christina Whiting, our Managing Director of Privacy, Enterprise Risk, and Compliance at Tevora, affectionately called PERT, and myself, David Grazer, the Practice Lead for Privacy and Vendor Management. And so without further ado, I want to introduce our panelists so we can get started. So first off, we have Alana Bobley. Alana is the principal and founder of 1111 Counsel and Strategy, a consulting and legal practice specializing in content security, investigative and data privacy strategy consulting. Alana's experience working companies suffering high-profile data breaches inspired a major career change. She now runs her own consultancy, helping companies in entertainment and other industries minimize risk, uncover facts, and obtain a clear picture of their handling and retention of sensitive information. She also serves on the leadership council of Secure the Village, a nonprofit whose mission is a cybersecurity Los Angeles. Next up, we have Kai Westerwell of Taylor Wessing. Kai is a partner at Taylor Wessing and a member of the practice area, the technology, media, and telecom practice area. He co-chairs the firm's U.S. group and the Menlo Park representative office. Kai is a certified specialist lawyer in information technology law and advises major national and international companies in all areas of IT law, e-commerce, multimedia, and data protection law. He has supported a substantial amount of national and international restructuring, cloud, and outsourcing projects, as well as many M&A transactions and IPOs. And last, but certainly not least, is Michael Helbush of TLD Law. Michael is a litigator at TLD, where he excels in several areas of law, including business litigation, intellectual property, cyber law, and privacy issues. His practice includes counseling clients on the security and privacy issues affecting their business and personal lives. Michael has presented on several cyber-related topics, including advising small business and nonprofits with respect to protection of customer records and personally identifiable information. Mr. Helbush is a member of the Sedona Conference's Working Group 11 on data security and privacy liability. Okay. So first off, as you said, we wanted to dig in and get an overview of a couple of key industries that our panelists support and what they're seeing in the lead up to GDPR. So Michael, let's start off with you. You're spending a lot of time thinking about this, I'm sure, but how will GDPR affect the digital marketing and advertising space?
Sure, and thanks for having me. I appreciate being here. First, I want to say that there's going to be kind of a shift in the way that we think about digital marketing because of the GDPR. I think historically, the concern has been how, at least from a marketing standpoint, has been how to exploit the data that you get through cookies and through online tracking and things like that. Now the focus, I think, is going to be on how do we get consent in the first place, because the GDPR makes it a lot more difficult to get consent. You know, think about the things that the GDPR requires before you actually, before the user will actually allow you to collect data about them. You have to basically disclose the following things: who is the controller or the controllers of the data? What is the purpose for needing the data? What is the duration of the use of the data? If the data is transferred outside the EU, to whom and which protections apply? You have to disclose the right to access the data, withdraw consent, demand erasure or correction, and then you have to talk about profiling and how that's going to be done by that. So if you're disclosing all of those things prior to someone giving consent, there's a high likelihood that those users are not going to consent to that. So the big focus, I think, is going to be on how do marketing companies, digital trackers, data collectors, data aggregators get consent in the first place, because I think that's going to be a big hurdle. So that, I think, is going to be one of the main topics. You know, the GDPR makes you've got to have explicit consent here. It's silence, inactivity, pre-selected boxes are presumed to be inadequate to confer to consent. If you look at recital 32, it provides examples of, you know, choosing technical settings for information society services statement or conduct that clearly indicates assent to the processing. So it can't just be the I consent by using the web page. There's got to be something more than that. And there's been a lot of talk now about how is that going to look in terms of when people consent to data collection. Is there going to be a layered approach for giving consent to tracking or collecting of data? You know, it's got to be checked the box, because there's so many different data collection uses, and each of them has to be explained. How is that going to look, and how is that going to affect the user's experience with a website? So that, I think, is going to be the main point. The second thing is the GDPR gives data subjects the right to withdraw consent at any time. So, you know, what it says under Article 7 is that it shall be easy to withdraw consent as to give it. So the controllers must inform the data subjects of the right to withdraw consent before it's given. And once it's withdrawn, data subjects have the right to have their personal data erased and no longer used for processing. So I think down the line, I think that's going to become an issue here, because, you know, we talk about getting consent in the first place is going to be a big challenge. And then, you know, companies and digital marketers especially have to be prepared for what happens when the user no longer gives that consent and wants to access the information they have or have you erase it, things like that. So those are going to be big topics I think we need to address, that companies need to address, at least digital marketing companies, within the GDPR. The big revelation for all this, I think, is going to be coming with the e-privacy regulations that are going to be coming later this year, hopefully. They'll expand more on the use of cookies and tracking technologies and what you specifically have to do, but the framework's already there in the GDPR. You know, the shift has been, we want to make informed consent about use of tracking and cookies and things like that. We want to make sure that that's explicit and the user understands what's being done. And so those frameworks are there under the GDPR. The challenge for marketing companies is going to be how to implement those and how to really maintain their level of collection that they've gotten through the use of cookies and tracking technologies historically.
Okay, great, Michael. Thanks so much for that overview. We'll dig in a little bit further in the upcoming sections of the webinar here today. So moving on to the media and entertainment industry. Alana, for someone who has worked within the media and entertainment sphere for many years, how will GDPR affect those industries? What are you seeing today?
Oh, in many, many ways. And a lot of what I wanted to focus on was just the ways in which the entertainment and media industry face unique challenges. There's obviously challenges that all companies and all sectors are facing, but entertainment in particular, and similarly a lot of other media companies, are really going to experience some unique ones when it comes to compliance with Article 30, data mapping, with later on with vendor management and breach notification requirements, which we'll talk about a little bit in the later section in more detail. But there's a lot of different things. And just to start out, one of the ways that it's particularly challenging is just the vastness of the organizations and where the data may be collected and kept and processed. Internally, it's very siloed, and many people would be collecting the same data, not necessarily knowing what others are doing. And uniquely, in particular, especially with so many television and theatrical productions, basically crew are using their own personal devices, not just their phones, but their laptops and their personal email addresses. And that's been a problem throughout the industry for a while. So in many situations, data that could be subject to new requirements are being kept on people's personal devices or email, personal accounts all over the place. And it presents extremely difficult challenges for determining where everything is and for controlling it, as you can imagine. There's also the issue of sometimes the uniqueness of the way it's collected. There's, rather than just being regular employees, there's so many freelancers and independent contractors. There's so many different projects in which sometimes it's the same crew on multiple projects, and sometimes there's just someone that works on one for a couple months or so. And sometimes they're hired through a payroll company or through an extras casting agency or a company loaning someone services. So there's many different ways in which, what would normally be traditional employee personal data could be collected, which may involve vendors. It's also, the data is also being kept for a while because there's residual obligations to pay, writers and actors and others working on a film, for example, years later, and same for net proceeds and gross proceeds participations and other approvals in the future. So there's definitely a need to keep data around. And there's also the fact of it may be transferred when you sell a TV show or a movie or license a certain territory. There's a lot of data that may be passed along to multiple people at these other companies in order for them to comply with those later obligations, for example, or to review the rights. So the data, the movement and as well as the very simple fact that on an international production, there may be the need to move the data of EU residents to other countries, of course, presents its own challenges, of course, as well. There's also, especially talking about foreign productions and also productions in various states in the United States, there's various tax incentives and credits and programs in which you might need to be providing data for different people working on a production. There's and there's also the sensitivity of the data, which we'll talk a little bit more later, but the fact that for a media company, there's often the personal data may involve certain high profile individuals, certain celebrities that many people want to get their hands on, and it could present certain issues there. As well as the fact that there's union membership references all the time, which is qualifies as sensitive data for the GDPR. Health data may come into play in atypical situations in which there's medical exams required for bonding a picture, for a studio to proceed, for getting insurance, for certain high profile players. So we're talking about very sensitive data that may be collected from data subjects that would be of interest to often the average person. So it would be quite different. Beyond that, there's of course traditional customers like another company would have. There could be promotional signups and data collected there, as well as obviously purchasing directly from a company or through a data processor. And times there could be something that's being collected by a co-promotional partner, like someone selling a product, a soda company, something like that. So there's really a vast web of ways in which the data will be collected, potentially, as well, there could be 2 data controllers, there could be many joint controller situations when 2 companies might join in together to make a movie and one is a lead, but other might have access to certain information. And sure.
Sorry, I was just going to say, to kind of, along those of, disassociating from, data and where that collection goes, I think there was a timely question that actually, came up from one of our attendees that said, thoughts on the removal of consent. If the company disassociates the user from the data, but keeps the data, will that be a common practice?
Are you asking that of me? Sorry.
Yes.
I don't know that there would be much situation in which they could disassociate the user from the data in the entertainment and media context. I mean, certainly when it comes to the big data, the data analytics portions of it, but in a lot of the unique situations, it's really going to be, it's a little bit harder to disassociate.
Yeah.
Okay.
Makes perfect sense.
And I think it would need to be anonymous. I mean, I think if it's completely there, there certainly could be ways of doing it where it is appropriate when it's an analytical situation.
Great. All right. Well, thank you, Alana, for that. And thank you for the great question. So Kai, you've had a front row seat to data protection law in Germany. And now you get to work with some of the most innovative companies in technology up there in Silicon Valley. So how will GDPR affect the growing Internet of Things and other evolving technologies? What should we potentially be on the lookout for?
Well, I think I can just echo what the other speakers, Michael and Ilana, said before, but even more in this space. All these IoT evolved technologies. I mean, I'm now in Silicon Valley, and as you said, I'm a German qualified lawyer. I lived in Germany for 18 years doing privacy. So I see it from a little bit of a different perspective sometimes. But since I'm here like 3.5 years, I see how all these companies are using data, and not only it's just using specific data, but using data on a very broad scale. And that's I think the important differentiator for these companies when it comes to GDPR. GDPR applies to the processing of personal data, wherever and whenever and with whomever you do it. So if you think about all these Silicon Valley technologies that we're talking about, they're all data heavy. You said IoT. IoT is a cloud-based service usually. It's data heavy, of course. And the international processing of the personal data, understood in the European sense, which means including IP address and the like, is of course something everybody does when working in the in the IoT space and the cloud industry. And think of IoT like this typical B2C applications. It's obvious that automated or connected homes, each refrigerator has that IP address and it can be located being in my household, and it can tell you what I'm eating every day. So that's, of course, a very, very high field of applicability of the GDPR in the future when it comes to Europe, but even B2B applications. If we were not talking about just pure machine-to-machine communications, which rarely is the case, it usually contains also contact details, mail address, or admin data, and so on and so forth. So this is personal data. Think about autonomous driving, a big topic right here in the Silicon Valley, or self-driving cars. They're all working with location data. Location data are the important data for all these services, but the same was true for mobile services. Location-based data are important. And what you see now, our cars become our mobile computer. So the cars have even more data on them than our personal computer has when we walk away sometimes. Or future, think of blockchain technology. Blockchain is, of course, a data security application, but also data heavy. Think of the financial industry applications of blockchain or Bitcoin on the other. Last but not least, I mean, and Ilona, you mentioned it, artificial intelligence would not be possible without big data. Big data is the important part of AI, and it needs an unlimited amount of data. And Ilona pointed out whether or not these data are anonymized, which makes them not personal data under European law, is pretty difficult sometimes to determine because people think differently of anonymization in the US than in Europe. In Europe, it means there is no way you can re-identify the individuals by the data. So that means they're gone forever. And when you look into the technologies that are out there, most of these technologies are at least not 100% safe, that these data can never be brought back to the individual. And think about AI in healthcare, visual analytics. This is high sensitive personal data. So everything around here is very data heavy. So the GDPR will definitely apply to everything, which brings me to the second part of it. The services we're talking here, and in particular IoT service, or most IoT services, are truly international. And that means it does indeed include the processing of EU data subjects. You pretty rarely find a localized version of IoT services. You do find it now because of the GDPR, or even, as I said, I come from Germany. In Germany, we see it for a long time already, that even the big ones from the Valley open up servers in the EU to provide localized EU services or even localized German services, because the customers are asking for a localized storage and processing of the data. But the GDPR will definitely apply to all of this, which I think is very important, even for companies who are not in Europe right now, because as you know, the GDPR is applicable to all companies around the world who are working with EU data. That's important. Thinking about what we just learned from the other guys, Article 6, consent, contractor purpose, and all this, for IoT services, usually not possible. We're talking about process or controller situation, and we'll come to this in a minute. That's one thing. But even more important, all these companies have to do the data mapping. And as you can imagine, for the services I was just talking about, the data mapping is extremely complicated. It's not just one company. You have a ton of providers around you helping you to do whatever you do. So it's always a bit more, let's say, challenging to perform the right data mapping, in particular in the area of the evolving technologies. And last but not least, as you know, just one sentence here, and this is the most important one, you know that the right to transfer and the right to be forgotten is now in the GDPR. Think about how to be forgotten in the IoT space. Think about how to be forgotten in the AI space. So these are challenges all the companies we're dealing with here have really to look into if they want to do further business with Europe. So I think the GDPR will affect the entire industry to a very high extent.
Yeah, and I think that, and Kai, I think that's a great, lead in to, what we're going to do in these next sections. So I think let's move back to Michael, and then we can kind of continue to tackle all these trends that we're seeing. So Michael, what are your topics of interest, or what are the special topics within the digital marketing advertising that you think are going to, specifically about GDPR, that are going to affect this space, digital marketing and advertising?
Sure. I think because of the strenuous barriers to getting consent in the first place, especially on behalf of digital marketing companies or data aggregators, there's really going to be a focus back on trust. And really the idea is that you've got to convince the data subject that you're trustworthy to give them, so that they give you your personal data. Technology vendors with a first-party relationship with the data subject are going to have a huge advantage in this landscape, because they're providing a service that the user wants, the data subject wants, and so they're going to be more willing to give consent to the tracking or data collection because they want that service. Whereas if you're a third-party vendor and you're really just there to collect data without giving anything in return, I think you're going to be at huge disadvantage because the data subject doesn't really have that incentive to give consent to that, and there are going to be ways that the data subject can distinguish between a first-party vendor, a third-party vendor, with regard to data collection tracking. So the goal for digital marketing companies, especially third-party ones, is going to be, how do we figure out how to get consent from the user? And can I get the consent, and then can I do it properly? And then the second question, I think, if that's not feasible, if that's something that's going to be difficult, is can the marketing companies find a way to create targeted advertising without the use of personal data? you talk about you've got to go you can do contextual advertising. If you're looking at if you're reading an article about the newest Nike shoes, you can have an ad for some other shoe company next to it. That sort of contextual advertising. I think you got to go beyond that and try to figure out a way to get interest-based advertising that maybe use non-personal data and is able to focus on collection or targeted marketing without the use of personalized data. It sounded like you were going to ask a question.
No. Continue. We got a few in the queue. If you want to take a couple.
Yeah, sure. That'd be great.
Okay. So one question is, do you see companies splitting their view of IP data to processing data, logs on network versus tracking of an end user for companies who will qualify the use of the data as PII and other data to be used in other means? So essentially interpreting their view of intellectual property to processing of data on does it qualify for GDPR or not? So looking at the gray area of does this apply or doesn't it?
Fun one to unpack.
Yes.
I think I understand that question, and I think the answer is you've got to go back and look at the purpose behind the GDPR in the first place, and that's it's the right to the protection of data, and especially in the EU, there's that fundamental right to privacy and the life of family. So the whole goal is to be explicit about what you're doing, be explicit about what you're collecting and how you're using it. And that's, defined in the GDPR. You've got to be very clear about, consent must be specific to each data processing application. So to the extent that you're going to parse the definition of PII versus other sorts of data, I think it's going to be very difficult, and I would err on the side of precaution when doing that, because the GDPR does make it pretty clear that personally identifiable information is a lot broader of a concept in the EU than it is in the US. And, there's a whole other section about pseudonymization of data that, would be a whole topic in and of itself. But I think you got to be very clear, and I think it'd be foolish to kind of parse words on the definition of PII, especially with respect to the GDPR.
Yeah, and I think that's a great response because, that goes into, what Kai was just discussing regarding, IoT and AI collecting a ton of information. It's really around, like you just said, it's kind of hard to parse out what is, PII versus what isn't, and to also take into consideration, the regulations that are in the EU as defining what PII contains, because it's not just about a person's name. There's a whole slew of other data that makes up PII as a whole and needs to be factored into, determining is it applicable or not. So it's expanding out just what the US-centric approach is for PII and actually broadening that into the countries that you may have those devices in, or you may be supporting patients or any kind of customer base itself. So definitely great info.
Okay.
Yeah, and I think a comment on that is if you think about the purpose of data aggregation for marketing companies, the whole idea is to create or to collect enough data that you can target a specific individual. It's cross-device tracking is going to be one way to do that. So the more and more data that you collect, that you can say, I'm narrowing down these data sets to I can identify pretty reasonably an individual without maybe even knowing their name or their username or handle or anything like that. You get to this scenario where, personally identifiable information is a lot broader in that context, because companies and it's getting a lot easier to identify a person because there's so much of a broader data set to use. And so narrowing down to identify a person is a lot easier, especially with things like AI and other processes for collecting the data and identifying those people. So I think you got to be very careful about trying to get around the what is PII.
Yeah, absolutely. And to that point, that corresponds to IP address as well, from where the computer is actually coming from, because you can essentially, based on, you know, that IP address, maybe pinpoint an individual if it's combined with other data sets. And so I think that's an important part too, in order for, you know, companies to think about it. IP address is included into that realm.
And Christina, may I ask one thing, because I think that's important, Mike. That was great, Michael. One thing I think is very important: the GDPR doesn't tell 100% what does that mean, anonymization or pseudonymization. It's not clear on that. And I can give you an example. In Germany, we were talking about, like, for 5 years when the German Act came in with the anonymization stuff, what does it mean to anonymize an IP address? Right, and you're talking about that, and we were always of the opinion you have to take out the last 2 octets in order to make it anonymized. Nowadays, they say, like, the last octet is okay. But what in, like, 5 years' time from now, when you can localize somebody, you know, individually for a meter, now it's like 100 meters or something with the last octet missing. So this is subject to change. So that means as well, you have to be aware of any changes here. The better this technology is, the more you have to anonymize in the future.
Right.
Great.
Definitely great follow-up.
Okay, well, Kai, we're gonna continue on with you. So, as we've gotten an overview of these evolving technologies, are there any special topics or trends that companies should be looking at when they're evaluating these newer technologies? I think a lot of that kind of correlates to what Michael's been talking about as well.
Well, actually, I mean, the areas we are talking about here a lot, and this is something everybody should be aware of, the GDPR now provides also for requests for compliance by design. So that's something, you know, people think about. We comply with the GDPR by mapping, by having new contracts in place and everything, and blah, blah, and all that stuff that we're doing. But of course, you have also to think about a lot of products, in particular these new economies, evolving technology products. They have to look at privacy by design. If they want to sell their product to somebody who has then to use the product, wants to use the product, the technology by itself has to provide the means for the controller then in the very end to your customers can comply with GDPR requirements. And that example means, like what Mike pointed out, like there's a tick box for consent or there's an opt-out. And can you forget somebody in your very complicated application? This is something the engineers have to build in right now. And I mean, as you know, GDPR is kicking in May this year. Can you imagine that takes much longer time to, like, say, bake in privacy by design in a product that is not compliant at this point? And it will, of course, hinder your selling in the European Union, but also in the US because the customers are asking for it. That was something I think about.
Yeah, that is. So kind of tailing off that a little bit, I mean, is the best strategy for some of these companies to, you know, as they're evaluating, as organizations, as US-based companies are evaluating, you know, the implementation of these new types of personalization strategies, IoT technologies and all, and that, is that digging then in deeper to the understanding of, is privacy by design actually being implemented deep into the development life cycle? Or should they potentially be approaching it, you know, from, you know, a different angle, different questions?
I think we are on a way to make the developers and, of course, the strategists understand that you have to bake this in. And the earlier, the better, the less cost you produce in the very end. Indeed, nowadays, companies have to possibly change their products, actually existing products, which is difficult. So you get a lot of pushback here. But when you start baking in for, like, the next future, I think it's much easier. And we see, I see personally a lot of development right now where all these companies are working with to get them GDPR compliant, or they might even be already, that they are really thinking about having, example given, the DPO or compliance officer be involved in every single development of new products or new applications. And this is, from my understanding, it should be under the GDPR, because otherwise you cannot safeguard A, the rights of the data protection officer, and B, of course, to have the privacy by design, compliance by design ready when you launch the product.
Okay.
Yes, absolutely. So Kai, there's a couple questions in here, really around ownership of business email address. So how does the business email address, factor into GDPR when, employment agreements say employees don't have individual ownership under email addresses, but then also, company email addresses are, being shared with, processors and other companies requiring communication. So who owns those email addresses, and does an individual have a right to have it removed when they leave, or does the company maintain that right? How does that relationship look?
It's a bit difficult because you are talking about ownership.
Right.
Privacy in Europe does not talk about ownership. It doesn't talk about a private human rights, right? So that's different. The ownership of an IP address, this is kai@westerwelle.com example, kai@televesten.com. This is of course my company. My company owns that IP address because they registered it for me. However, if it identifies me, it's also including personal data. So on the other hand, there's like two sides of this matter. The other side is that the company is giving away my personal data, telling somebody I am working with this company. I have this email address. I may even have this telephone number. So these are personal data the company is giving away. And indeed, what if I leave the company? Then under European law, you have the right. On the other hand, no, let's say it that way. The employer has the obligation after a certain amount of time, when there is no other reason to keep this information actual, like the entire personal data the company has about the employee or former employee, to delete this data after a certain amount of time. It's not only the right to be forgotten, it's already a legal obligation coming out of the obligation of the minimization, data minimization obligation. So to answer your question, yes, if I don't want the company to keep my personal data, example, given my email address that identifies me personally, I can ask the company to remove it, and the company has to.
Yeah, no,
So
I mean, that's fantastic. And that leads into, the privacy by design. So it's not just privacy by design for external customers and clients that you're supporting, but it's also for internal data and how that is handled, and what is that protocol and procedure for, and what kind of elements are, factored into that privacy by design and that overarching program as a whole. So absolutely fantastic insight on that one.
And then you're right. I mean, a big part of the GDPR project, and I think Ilona and Michael, you can echo on that too, hopefully, is HR. You have to read your entire HR process. Just because somebody is employed at your company doesn't necessarily mean you can do with the data of this employee whatever you want to. It's the contrary. In particular, what you have to understand, not only that the GDPR provides for a certain protection of also, of course, employee data, it also gives the member states the option to exceed the protection of employee data that is provided for in the GDPR in local laws. And you might imagine, for those of you who are dealing with Europe, they know that in particular in France and in Germany and also in Spain, the employee data protection is a pretty high level protection. So it could even be in the future, we might see a protection of employee data which even exceeds the actual requirements of the GDPR. The actual development in Germany they don't lead to that direction, but I would expect there will be some influence from the employment courts to even raise the level of employee data protection in the member states.
Okay.
Yeah, no, fantastic.
That's something to definitely keep an eye on. All right. So Ilana, what special topics are you evaluating as it relates to media and entertainment in GDPR?
Sure. Well, vendor management is one of them, and in this case, it's broader than just traditional vendor management. So it could include, there's so many that could potentially be stepping into a process or role, and so, and especially as a former transactional attorney working for different media and entertainment companies, it particularly, scares me to think about just how many agreements might need to be revised in order to comply with the obligations. There's obviously data transfer agreements which are required, and there's the requirements for data processors that are very clear. But there's many situations in which like an individual would actually be collecting information, like a crew member, and you might want to make sure that they're being mindful of what they're collecting and not collecting anything and being required to delete it and give it back. And those might not be in those forms. Generally, as far as the hiring of vendors, there may be the more traditional vendors that other industries would have, and that would go through more typical procurement departments, and that's one thing. But on the other hand, there's so many companies that are hired in the process of making a movie that would then have their own HR function and hire crew members. So, for example, in many cases on a motion picture or a television show, very common when it comes to unscripted television in particular, another company is doing all the hiring of cast, crew, everything. Sometimes it's in another country, and they're collecting it all, and they're doing it all on behalf of the owner and the rights are flowing up to the owner. So it's pretty likely that in those type of situations, the studio would be the controller and the other company would be a processor. Then there's others that make it a little bit more challenging, because it could be, a visual effects company that you're hiring to create visual effects for the movie, and you may not be in control of the fact that they happen to hire someone that's an EU resident or something. And so there's a lot of gray areas there. But generally, as far as on the contractual basis, it can be a challenge with entertainment companies in particular to update agreements. I speak as someone who used to be anointed the forms person in various places, and traditionally you tend to use the same old agreements, like for ease of negotiation, and it can be hard to get people to change. I have to admit, as recently as just a few years ago, I was still removing telex from forms. Definitely faxes all over the place still, but things are a little bit old-fashioned, and people tend to want to do things the way they've always done them. And culturally, there's also the fact that there's, people want to bow to talent and not, they want to accommodate them, and they don't want to make their lives difficult. That happens quite a bit with any kind of on-air personality or director or actor or something. So there's lots of cultural issues in the industry that might make it more challenging to provide the kind of constraints that you need to, and to update the agreements in the way that you would need to as well. And there's also not only with on the end of producing the product, but there's also the distributing end, and the agreements with licensees and distributors around the world. There's often so many countless numbers of agreements for each product, and so needing them to require. Sure. Mm-hmm.
So Alana, in your opinion, it does make sense for organizations, particularly, I guess really beyond the media and entertainment industry, to start weaving in some additional GDPR or European privacy-related questions during their vendor vetting and auditing processes.
Definitely. Yeah, because you never know. It's not very clear. There could be residents hired in different situations. There could be something that's produced abroad or a component that's produced there. And it's really, in fact, I think this is actually a good thing in a way that more stringent vetting will take place. There's already a culture of vetting foreign production services companies, for example, for FCPA compliance. There's, that has already been ingrained after a while. There's some of that goes on, but otherwise, when it comes time to, especially to security vetting, there's not that much as you would expect. And so certainly the questions into that and the actual handling of the data, the deletion, make sure that you're going to be able to comply, because you're responsible as the data controller. There's no doubt that you're going to have to ask these questions of those who may be the processors, because they're often small companies and they may not be in compliance.
Yeah, and that's definitely something you have to contend with, is the size and scope of some of these vendors that are utilized on set. Okay. Well,
perfect. So we were just fielding kind of questions, in between. So you know, we didn't ask all of them, but, you know, I've been responding to individuals, you know, as they, you know, come in. So with that, you know, we kind of wanted to move into, you know, the last round, which is predictions.
Yeah. So, Michael, do you want to kick us off with some of the predictions that you have for the next few months, and as GDPR becomes an enforceable legislation?
Sure, and I can kind of follow up what Ilana was talking about. I think the big thing right now is everyone's trying to figure out compliance on their end on the first party basis. How do we comply with GDPR? What are we doing specifically? I think what you're going to see in the next few months or few years even is how are we making sure that all of our vendors and all of our third parties are in compliance as well. And obviously that's an aspect of compliance, but I don't think it's being looked at as heavily because, you know, the GDPR says basically every controller or processor who's touching that data is going to be jointly and separately liable to the data subject. So there's going to be a lot of concern, I think, among the parties saying, how are we shifting this risk from one another contractually, and how are we vetting that we're making sure that our partners and our third-party vendors are complying with the law. That's going to be a huge thing that I think is going to, as soon as the let's get our own company compliant, let's make sure we're doing that. And the other thing I think is going to happen is that insurance is going to change a lot with respect to this, because there's huge liability associated with a GDPR violation, and insurers and reinsurers even are going to have to look at this, especially for the larger companies, to say, how are we going to approach violations of the GDPR? And I think it's going to change the insurance market in a lot of significant ways. So, you know, those are two topics that I think are really going to be heavy in the upcoming years.
Okay. Ilana, what about you?
Sure. So that's great. So yeah, I certainly agree with what Michael said, and as I alluded to earlier. So there's a couple things. One, I'm optimistic. You know, I do think that these requirements are going to lead to companies in the U.S. finally really getting a handle on their data. I mean, I think that there's so many that aren't really doing any kind of mapping exercises and really don't know just how it's so scattered and don't have a good handle on it. And a lot of it really takes in-depth, you know, one-on-one discussions with people and to really understand where things are, both paper and digitally, of course. So I think that will have a positive impact in which companies finally turn attention to that and therefore limit what they collect, limit what they're keeping, and streamline things and keep things organized, and obviously with record-keeping controls that they might not have otherwise done. And also, I think that it should have a positive effect in people being more prepared for incident response readiness, doing tabletops, really having a plan in place. We didn't get to talk that much about the data breach notification requirements, but a 72-hour turnaround is really tight. And the assessment of risk to the rights and freedoms of natural persons, you know, it's a complicated assessment, and a lot of that is really dependent on the subjects. So, you know, whether or not it would result in a high risk to the subject that would require notice to them, or just any kind of risk that would require notice to the authorities, it's going to be a delicate assessment that's going to depend on the industry, on the data subject. You know, obviously in entertainment, there's particular sensitivities with respect to data on particular people, and so something that might otherwise not be a high risk would be. So there's going to be potentially more requirements for giving that notification, and just such a quick turnaround, and you really need to have all your ducks in a row. You really need to have your team in place. So I think those are two effects that it's going to have that will hopefully be positive for everybody.
Yeah, great insight on that.
Okay. And Kai, what are your predictions?
Well, actually, my first prediction is I think we will see a lot of panic until May 25th. I think that's what we already see, because, I mean, as you know, the companies woke up, some companies woke up late, others woke up early. But I also think, like, you know, once the GDPR is implemented, we will have another wake-up call for those guys who have not thought about before. So we have another, I think, wave of GDPR compliance projects, which I think is interesting. And the next round, I think this goes a little bit into the direction of what Michael said. I think in the next round, we will see the first audits and penalties happening, like to the end of this year. I don't think that the audits will happen earlier because the European regulators already told them, you know, we don't have the power, we don't have the people to do that, and we give you some more time. It's not like a grace period, but they will not enforce as long as you can really show that you are acting positively, that you are approaching that. But to the end of the year, I think we will see the first audits, we will see the first penalties happen, and that's going to be very interesting. And last but not least, because we are in the US, I expect, I don't know whether I'm right or wrong, that we'll start seeing litigations on privacy. And I assume, from my perspective as being European living here, it might be more in the US, because we have class actions here, we have bigger penalties, you get much more money out of breaches and everything. So that's the reason why in Europe, we don't see that many claims on data breaches. We just don't, because the penalties are not, sorry, the damages are very difficult to prove. That's what you have. And the other thing, I think what we see in the long term, and we already see it right now, I think the GDPR becomes more and more the world standard. So we're actually talking about a European standard for all the European states, leveling up the data privacy in the EU, which is nice, and it's helpful, but also difficult. I understand that. But on the other hand, you see it all over Asia right now. There are a lot of Asian states now applying or thinking about applying the European standards because they're there and it's easy and it makes them, you know, it gives them a high privacy standards. We see the same in Canada because Canada is one of the countries as like New Zealand, Australia, but in particular for the US, Canada is important. It's a state that provides for adequacy. So how can you further on provide for adequacy if you don't step up to be compliant with the GDPR in this country? So I talked to the Canadian Data Protection Office as well, and they said, we will be compliant. Same, by the way, holds true for the UK, and we all have to think about Brexit in the future. But the UK also already said, like, they want to be compliant, stay compliant. In South America, you see also development. Mexico just implemented a new law, which is pretty much aligned to the Europeans, and there are others down there. So my prediction would be GDPR is not something that goes away in a couple of years. I think that's something that will even extend over the world.
Yeah, that's great. And so follow up, do you have any prediction on when or if, the US is going to adopt something similar and enforce it here?
Was that question to me? I don't think or I mean, what you see, by the way, and I think Michael and Ilona should answer that because I'm a European lawyer, but actually have you had a look at the New York Right to be Forgotten Act that's actually about to be implemented in the next couple of months. So, I mean, that's something, everybody is thinking about how you can even think about right to be forgotten in Europe. You're crazy. But now we see the first law in the US possibly being passed in a couple of months. And also, I mean, California has a very high standard. So I don't know to what level in the US we're coming up with, but we should not ignore the developments around that.
Yeah, that makes sense. And, quick question for Michael, as a follow-up to a lot of these discussions, given that this is, obviously really focused on EU, and as, Kai was mentioning, this is something that is a global trend that's taking place for privacy, but thinking about a US-centric approach of, say you're, a large hospital or healthcare provider that is providing services only in the US because they don't have an international presence, but it's, US-based company, and they're providing services or treatment to, an EU resident. I mean, is there jurisdiction for them to, fine a hospital or a healthcare provider if they're not complying? And is there any, predictions of, what that process would look like?
Sure. Well, I think the first thing to say is it absolutely would. The GDPR would apply to data that is collected from EU citizens. The reach of the GDPR is extraterritorial, so it's not that you have to be a company within the EU to be subject to it. It's just, are you collecting data about EU citizens? So I think it would apply. The next part of that question is do I think that there's going to be enforcement actions against let's say a local state, local hospital or even a national healthcare provider for, maybe minimal touches with EU citizens on their healthcare data. I don't think that's likely. Maybe Kai can answer that better, but I don't think that's going to be on the top of the list of enforcement actions. But that being said, I don't think it's a bad idea for healthcare providers to get on board or try to start implementing the standards that the GDPR lays out, because I think that it is going to be it's going to be the industry standard for not only the globe, but a lot of individual states in the United States very soon. I don't think that we're going to have a national law anytime soon, but especially places like California, which are pretty stringent about privacy rules, I think we're going to see something very similar to that soon. So I don't think it's a bad idea to start complying with it. I don't think that companies that, occasionally deal with EU citizens are going to have a lot to worry about in the near future, but and whether or not the enforcement actions will be enforceable against a company like that, it remains to be seen. But I think that we'll have to wait and see.
Okay, yeah, no, fantastic. I think that's great insight into that. Perfect. With that, I know we weren't able to answer everyone's questions as a whole, but hopefully we're able to answer a majority of them and the more complicated ones that people would want to see immediate feedback on. So with that, if you do have additional questions, please feel free to reach out to any of us. We can help you, through this journey, whether it's, from the legal side of the house, security side of the house, risk, what have you. But I definitely want to take the time to thank our three panelists for joining us today. Absolute fantastic, information and discussion points being shared, so relevant to today. That'll absolutely be relevant into how people are actually building their privacy by design, their privacy programs, factoring into, security, risk, compliance, legal perspectives as a whole. Absolutely thank you for joining us, and definitely thank you for all the attendees who joined us. Again, if you do have questions, please feel free to reach out to us, and we can help coordinate with the panelists themselves if there's any follow-up information and or additional contacts that you would like to have.
Yeah, thank you again, and please look out for the slides. We will be sending those over in the next day or so. Cool. Thank you so much.
Thank you, everybody.
Thank you very much.
Thank you.
Thank you.